Are we introducing ourselves, I guess? We're live. Hello. So I'll go first. My name is Alex Miller. Joining me today on this legal panel is Walt Lehmann and Kaylee Kruschke. Did I get that right?
Yep, okay. You got it.
All right. So we'll just do a little brief introduction and then we'll dive into some topics. If anyone watching has questions, please put those in the chat or the comments area, depending on what platform you're on. And we want to take questions the entire time. So any thoughts you have, just go ahead and drop those in. So introductions, like I said, I'm Alex Miller. I am a composer and an entertainment attorney in Minneapolis. I work with filmmakers, musicians, bands, score composers for film and television, and help musicians that are independent and want to set up their own publishing or record label.
Hi, Alex. Hi, Kaylee. Hi, everybody out there. My name is Walt Lehmann from Lehmann PLC. If we were in person, I'd hand you one of my cards. So here it is. Nice to meet you. I've been practicing in the art, entertainment, and museum law space for over 25 years now. I represent a wide variety of content creators and arts-related organizations, and have dealt with issues from copyright, from intellectual property issues like copyright, trademark, privacy issues, all the way to business law questions, how to incorporate, structure your business, and lots of contracts and licensing, and trying to make deals happen for people. During the pandemic, I had a couple of interesting projects that added to my portfolio, I guess. I wrote a textbook on museum law and taught a course this past January at Mitchell-Hamlin Law School on museum law. And I also finished a course on art appraising over the last year, working on my way to become a certified art appraiser. Some recent issues that I've encountered in my practice are a number of people self-publishing books. And that's becoming a good thing to do during the pandemic when you got a lot of time on your hands. I've had a lot of issues recently with dealing with online performances, recording and streaming live performances online. And I'm sure we'll talk about that here. And then dealing with artists' estates. I think it's kind of a topical issue to start thinking about what you're going to do with your creative work and how you will keep your legacy going forward. So looking forward to the conversation. Kaylee?
Hello, everyone. My name is Kaylee Kruschke, and I am an associate attorney with Mendoza Law. I also practice in the arts and entertainment area, and I primarily help artists and musicians with filing for a copyright, registering for a trademark, as well as helping with some sync licensing deals, mostly right now with musicians who are in movies. So yes, I'm also looking forward to this discussion.
Okay. Again, if you're just joining us, drop questions in the comments section or the chat, whichever you have available to you, depending on what platform you're on. We do want to take questions throughout. So we're going to cover kind of high level, but lots of stuff, and every topic you want us to discuss. This is your chance to have 3 legal minds for $0. So
you get what you pay.
Fire away. Oh, Walt's being modest. So, okay, we've got one question so far. I am curious what you think would be some of the top legal concerns for an organization planning an in-person music festival in August. Okay, so to break that down, I think we should probably discuss the COVID situation and complying with whatever the current executive order says is allowed for gatherings and performances. There's a specific document right now that would explain how, I forgot what the number is, but it's on the website of the Department of Economics, I think. You can find this like 10-page thing where they put together what performers are expected to do. And there's some things in there, like when masks are required, how far you have to be away from the audience, how far away you have to be from each other. And so when those get updated, there's a new regulation, a new order that will be updated as well. So the current thing is online, and I think it's like 10 feet from any other performer and 12 feet from the audience or something like that. I don't know the gathering size.
There's local or municipal rules in some cases, perhaps, that you might want to be aware of. It's kind of fast changing, so it's kind of hard to keep track of. And in addition, if you're dealing with something that involves a union or a guild, it's possible that there may be some regulations out there as well. I know with SAG-AFTRA, they had promulgated a large, detailed thing on how you do a movie production in the age of COVID. So all those kinds of regulations you need to be aware of for these events and how they're changing. And I'm sure that the rules won't keep up with reality.
What tends to have happened so far is people make plans under what the current regulations are, and then they get changed, and the people that have an event and it's like a week away are scrambling to try and adjust to meet whatever the new regulation is. It's totally possible we go into more limited gatherings again, or into full lockdown again. We just don't know. So a lot of the contracts being written right now have all these just in case scenarios kind of mapped out. Like, if we can, we'll reschedule. If we can't, we'll refund you. And the other thing that's becoming apparent right now is how competitive the venue space is going to be for any sort of live event. Even if you're doing something outdoors, I know there's a lot of people planning pop-up events, but you want to be mindful about where you're having those with noise ordinances and if there's permitting required. Like, you can't just go into a park and be like, we're having a festival now. You have to get permission for that.
And you'd look to, I suppose, the local authority first for that kind of permission, right? If I was going to play in a park, I'd want to talk to whoever jurisdiction the park was in to find out what I needed to do, right?
Yep.
Yeah.
And everyone's competing for the same space, so.
Right.
Yeah.
Now, this live performance, I'm going to do this festival. What other things do I need to think about? In terms of, we've talked about bringing people in. I guess the COVID issue is what regulations govern everybody. How about for the musicians itself? Anything we need to be aware of in organizing the event in terms of agreements with the musicians, for example?
Oh yeah, sure. And Kaylee, you can jump in too if you have something to add. Any live event is going to require performance licensing, and usually the venue is responsible for that. So if you're the person setting up the festival, you're going to be responsible for getting the license to cover that performance. Venues typically, like brick and mortar venues, typically are getting what's called blanket licenses, which are good for a whole year. Usually, sometimes it's modified for seasonal businesses, but that is designed to cover any song that would be in a performing rights organization's catalog. So if, for example, you have a blanket license from ASCAP, then you have the license to perform any music that ASCAP represents under that license. And same thing, if you get the license from BMI, then you have access to all of BMI's music. And so for one-time events, they're not usually getting a blanket license because they don't need it for the whole year, and they don't have an established premise where they're going to have multiple events. They get what's called a per program license. And so you may need to pre-clear what you're going to be having performed, because you won't have a blanket license to just do anything. So that's the kind of thing to keep in mind, is you're going to be responsible for the performance licensing.
Yeah, and as you're saying, it's because I'm now the one that's organizing this, and it's not in a venue that has their own blanket license already in place.
Yeah.
Yeah.
Yep. That's one of the downsides of the COVID reality is people are finding themselves in the position of responsibility for these licensing issues, where before someone else would have been doing it for them. Like normally the band doesn't have to worry about this at all. They show up at the bar, they play, the bar is the one paying for the license, and no one thinks of it other than that. But as soon as we're going to a non-traditional venue, or we're streaming it simultaneously while we're playing for a live audience, now you're in the role of a broadcaster, or now you're in the role of a venue. And so you have additional things to be concerned about that you wouldn't have before. You would have just showed up and played.
Right. Well, let's talk about streaming. So we've got this live event, but we decide we want to, because we're restricted on how many people we can bring in or whatever, we want to share it with the world. So we've got that venue license, the blanket license, but do we need something else to stream?
Yeah, it's going to depend where and how you're streaming. If you are doing it on a platform such as Facebook or YouTube, and you're doing it simultaneously with your live performance, you're probably okay to just rely on the licensing that those platforms have in place. They have set up blanket licensing with most of the major publishers. There are some songs that are not in that blanket license, and there's no list to check to know what's in the license or what's not. And so what can happen is you'll get muted during your live stream if a certain song that's being performed happens to not be covered by that license agreement. But for most instances, you're going to be okay if you're doing a simultaneous live stream through a platform that's already got licensing in place. Where things can get more complicated is if you're trying to offer it like an archived version for people to watch later on demand, because now you need a license from the PROs to have that video on your website. But before you're even allowed to put it on your website, you need to get permission to have made a video of the music. So you need a sync license from the publisher. And unlike performance licensing, they can say no. They can just decide like, no, we don't want you to make a video, so you can't.
Right. The sync license is completely separate from the ASCAP, BMI, CSAC.
Yeah, you have to go directly to a publisher to get those. And Kaylee, why don't you share a little bit about how easy or how hard is that process to find the publisher and get the sync license?
Yeah, I guess I haven't had much experience with people trying to find the sync license necessarily. When I work with people, they usually approach me and they've already found it, which is kind of a good thing. But I can talk just a little bit about what the sync license is if you're unfamiliar with what that is. And so as we were kind of discussing, it basically allows the music to be synchronized with another medium. And a lot of times that is video. And in this case, it is if you're doing streaming. And so there's kind of two things that are involved in a sync license. And one is the master use of the sound recording. So if you're actually taking someone's sound recording that they have of their song, you have to make sure you have that piece, as well as the piece of licensing the composition. And so the composition is more on that writer publisher side. So if you have someone who's going to perform a cover song, for example, then you're really just focused on that composition piece. And a lot of times kind of tied with that sync license are those public performance royalties that you can also get if it is considered a public performance. And I can talk, I've had a deal recently that had several issues. So maybe just a couple things to think about with sync licensing. I know with my experience, it started out as essentially a quote that was sent to the artist. And that quote was very vague in terms, just kind of laid out what the song was, how long it was, that it was going to be used in such and such film. And then did say, you know, we're going to pay you one time, but then we're going to pay you step up payments, essentially, based on how well this film or, you know, streaming in any kind of content, how well it does, whatever it's being featured in. And it wasn't really clear in that quote what was going to be included to determine how well the film does. So what kind of profits or income that this film was going to make. Is it just box office? Is it the sale to a third party, the sale to like a streaming platform, any kind of distribution? Like, what was it actually going to be? Very vague. And so what I would say is, if you are working with a sync license, you want to make sure that you're being clear, if you're the one who's obtaining it, when you're actually going to pay the artist, and making sure that those payment provisions are really clear. Or if you're the one who is having their art used in a film or a performance, you also want to be very clear what you're being paid for. And if it's not clear, if it just says all media, for example, you should try to get that other party to give you some examples of what that is, what's included, what's not included, so you both understand what's going to happen. And the second thing that I've noticed anyway with sync licensing, and maybe less applicable in this live streaming context, is just assignment rights. And so in this particular case as well, this original quote didn't have assignment rights. And so later on in the process, the movie producers did want to sell the film, but they couldn't do that because you need written permission from the copyright owner to be able to assign it. And so having to come back and kind of renegotiate kind of ended up in a long, drawn out process. And so that's something to look for too, whether they're asking for those assignment rights right away, and whether they are or not. Something to also think about with that is just possibly asking them for you to give them written permission in order for them to assign it before they do, so that you understand what's going on with the assignment. And if they are hesitant to something like that, which is generally the case, they don't want to have to come and ask you every time they want to assign their rights and sell the film to somebody else. Another thing you can do is just ask for notice anytime there is an assignment, so that you know who you're working with at all times with the agreement. So anyway, that's just a little bit about sync licensing and some issues I've seen.
Yeah, I just want to clarify. Kaylee was talking about the ability to assign the license, not assigning the copyrights to the song. It's still a license. It's for sync, it's a licensing situation. So you still own the copyright. The artist still owns the copyright, and you're giving permission for the film to use it. But if you don't put something in the license that says the license holder can pass their license on to someone else, then you have the problem that Kaylee was describing, where they're stuck and they have to come back and be like, hey, can we give the movie to someone else with the music in it? Because technically I am the only one that can have the music. So
right. So what other rights clearance should we be thinking about? So we got this live performance, but we're going to stream it now.
Yeah.
And we've gotten the music licenses squared away. Are there other rights issues that are going to show up? I'm thinking of one that's right behind my head. Any kind of set dressing or staging that you include with your event, you want to consider whether you need to get permission to let things appear in the background, for example. And also in a location, do you have, I guess we talked about that earlier, the right to record on that location.
Well, yeah, we didn't say that specifically, but the right to have an event on the premises, especially something like a concert, because of, again, there might be local noise ordinances where you can't like have a concert in your backyard because there's an ordinance.
Well,
if you're filming on your own,
invite the neighbors, just invite the neighbors, and then we're
offer drinks, bribery. I don't know, that tends to work, but
that reminds me.
Actually, that's a different licensing issue. You can't serve alcohol without there's a dram shop law, right?
Right.
So ignore that advice. Don't bribe people with alcohol because
there was a trend in the last couple of years of sort of house parties where musicians would offer, they'd get somebody to offer up their house, and then they'd sell tickets for a little intimate concert. I know a couple of musician friends who do this. Do you see that going on now?
I don't know that MMC was doing some of that. Not during COVID, and I don't know when it will resume, but the hope is to get back to doing those and probably having them outdoors. But one thing we glossed over with the sync licensing aspect, Typically in a film situation, this is really important. In a film situation, they're going to want their video to be able to exist forever, and they can distribute it forever. And with a concert situation, normally you're not asking for the video rights forever. And a lot of times when you ask for a sync license to make your video of your concert, they will ask you how long you're going to have it posted and where you're going to have it posted. And I've run into situations where the publisher expects geo-locking, like you can only make it available in North America, nowhere else. And they expect you to take it down in 6 months. And they want a fee of like $6,000 or $7,000 for the one song in your video. And that's all you're going to get is like 6 months online, North America only. So sometimes it can be expensive to put these concerts together if you're going to archive the video and make it available, on demand. The other thing that's been happening, composers are in the classical space too. This is happening. Independent composers are finding themselves being approached directly by schools, other people that want to put on performances, and they're asking, can we have a sync license? The composer's like, oh my God, I don't know how to do this. What do I quote them? What do I need to know? What do I tell them? And so the important things to ask are, how many times are they streaming it? Is it happening just once live, or do they need to put it on their website or YouTube later, and it's going to be available on demand? And if that's the case, you want to know how long it's going to be up for, where they're making it available. If they're putting it on their website in addition to YouTube or also on Facebook, you want to know where this stuff is at. And then in a lot of cases, the way that streaming is presented, you're not going to get performance royalties in the way that you would if it was a live concert in a hall. And so you want to keep that in mind when you're figuring out a fair rate. The type of licensee also matters. If a nonprofit asks for a sync license, they're going to get offered a lower amount than a corporate project or a big budget film. It's just a fact. And so these are all, they have wide ranges for what the prices are. And you'll hear everything from like $100 to $100,000, like no lie, that's the range. And so if you're, an independent composer, someone asked you for a sync license and you're dealing with a school, it's a middle school band, they want to perform your song or whatever. It's like, you're going to have to work out something that's fair for both of you, but the rate is totally up to you to negotiate. So.
Great. All good advice. Yeah. Are there any more questions in that chat box?
Yeah. So back to, this is a COVID question again. If you're in a scenario where a performer, patient, or volunteer refuses to comply with the laws for masking, social distancing, etc., what actions can you take? I haven't had direct experience with this, but in a lot of instances, the venue staff helps with this, and they will post signs that if you don't comply with certain rules, then you will be asked to leave. Go to a Target store and they have stickers on the doors. They're like, if you won't wear a mask, we invite you to shop online. Like that's it. I know that there was a report put out suggesting that you make these conditions of the ticket, all the fine print you can put on the ticket itself. And so if they don't comply with those rules and policies, you can dismiss them from the event and they won't be refunded.
Yeah.
So.
Yeah, I mean, the enforcement of it it's almost more of a public relations thing in lots of ways. How are you going to handle it?
Yeah, and some of it's a judgment call. You don't want a fist fight to break out over this in the middle of your event. And
right, but you want to anticipate how you're going to plan for how you're going to respond if you're faced with some kind of
situation. On film sets, there's actually a person designated that's responsible for this, and so it would be a good idea to work out among your volunteer staff or your regular staff who's kind of the best at diplomacy and who's going to be the one that can talk to people about it.
Right.
So.
Right. Good.
Okay. Then there's some other comments. House concerts are huge. Lots of musicians planning house concerts for this summer. So maybe we should talk more about house concerts.
Yeah. I don't know. One thing comes to my mind is liability. Who's liable if something bad happens at that house concert?
Yeah.
I suppose the homeowner's got homeowner's insurance, but I wonder if it's covered. That would be a conversation with an insurance broker, I think. And
Or to make people afraid of having events at their house.
yeah. I mean, whether it's somebody trips and falls, or if somebody drinks too much and gets killed in a car accident afterwards, sounds like there's a lot of liability issues that could be raised. And of course, the stuff we've been talking about in terms of if you're going to stream it and everything like that, those would all apply in the house concert context as well. Can we think of anything else that, from a legal standpoint, that's particular to the house concert?
No, I think they may not even qualify as public performance. I'm not positive, because weddings, for instance, don't count as public performance. A house concert, I feel like, because there was a case on this, and the question was asked whether a company's holiday party was a public performance or not, and so it was just employees and their families. But the court decided that was public performance. So I feel like a house concert probably is public. So technically should be licensed for.
I imagine it
but
might be how you go about selling tickets and things. If you're just inviting friends, or if this is something that you're opening it up to the whole public. Anyone can come as long as they buy a ticket.
So the reality is the PROs probably aren't going to enforce things against house concerts unless you're doing this like every week and they get wind of it. But just for anyone that doesn't know, for venues, how it works, we talked about blanket licensing. There's an exemption for small venues where they don't have to pay a blanket license if they are under 3,300 square feet, but that only applies to their use of radio or television on their premises. That doesn't apply to their live music. And so what's been happening, and this is annoying that it's happening right now, but the PROs have started sending letters to all these venues that are trying to have live music like once a week. And they're like, oh, hey, by the way, you need to pay this blanket license. And it's like $500 or $800 a year. So that's been a little frustrating that we're just coming out of this. And the PROs are trying to help the songwriters who lost so much in royalties last year from performances not happening. But at the same time, it's a blindsided sort of approach that seems a little like a scam letter. Like people get these letters and they're like, is this a scam? Is this for real? Like this person's asking me for money and saying that they can sue me if I don't. And I'm like, yeah, I hate that they do it that way, but they will literally send spies to venues if you have an unlicensed performance and they offered you a license and you didn't pay for it. Then they write down all the songs that were performed in a given night, and then they go, oh, hey, we could sue you for copyright infringement, so you should really get this license.
Wow.
So,
if the $500 might be well worth it.
So musicians usually don't know any of this is going on, but like from the venue owner's standpoint, that's how this works.
That's right. You talked a little bit about on the streaming thing again. You talked a little bit about the difference in platforms, and we did a year ago, almost to the week. We did a program, you and I and John Munson.
That's right.
Standards. Did a program on Springboard for the Arts about streaming online, and I highly recommend people check it out if you haven't. It's under their sort of COVID emergency resources. There's a section on legal resources, I think. But in that, we were talking about the platforms, and you made a distinction between YouTube, which you mentioned here today too, and some of the other platforms. Want to go into a little more depth, like with Facebook Live, for example?
Sure. Yeah, it hasn't really changed much in a year. There were rumors that the PROs and the publishers were working with these platforms to try and figure out a new licensing deal. And the story was that fell through late last spring. Like they reached a temporary agreement. TikTok was the subject of its own large press debacle over licensing issues, but YouTube has a blanket agreement, and they have for a long time. The difficulty there is that you don't know what's in it. You can't check. Things can go in and out of these types of deals without anyone but the publishers themselves knowing about it. Facebook has something similar, but the biggest difference between YouTube and Facebook is that YouTube's algorithm is much smarter and better at detecting things. And Facebook seems to think anything and everything must be a certain commercial recording. And so people were having a harder time with Facebook and muting them because it thought it was, the way it works is it's actually looking at the waveform of a commercially released recording that's been provided to it. And then it's comparing that to the live stream. And so if you have the same song and the same instrumentation, in particular, the same tempo, then it thinks it's actually the same recording.
And it takes it down.
So then it mutes it because they really don't want people using Facebook to play commercial recordings because, you know, like live streamers, like gamers or somebody talking and they have music on in the background, they 100% want to crack down on that and not permit that to happen. But the algorithm doesn't distinguish between whether the music's being played by a human or whether it's being played in the background as an existing recording. It just thinks like, oh, that must be that song, so mute. And so that's the frustrating thing with Facebook primarily. YouTube's algorithm is a bit better. They have had issues with it, and it sometimes does flag things incorrectly, you know, thinking one song is another or something. But overall, YouTube's algorithm is just a little more sophisticated because they've been doing this longer. For the most part, you know, there's always the risk that you're going to get muted or you're going to get taken down. Most people are not facing lawsuits or anything for doing these streams. You know, you're going to get a copyright claim or it's just going to get an ad on your video. So
Interesting.
There's a different concern if you're using it in a commercial context. And this was happening to clients at our firm. Particularly if you use someone's existing recording and then they realize that you're using it in an advertising context, they will send a demand letter and threaten to sue you. And they ask for like many tens of thousands of dollars in that scenario. So that's kind of a different topic, I think, than musicians who are performing it themselves. But that's one thing just to know is if you cross the line and it's a commercial use, you're more likely to face trouble beyond just a takedown.
Yeah, that's very true. Very true. Also true in visual arts as well. With images that you use in a commercial way.
There are some really cool platforms, and check out the blog Water and Music. Sherry, who writes that, has been compiling a list since COVID started of all these new streaming platforms that have emerged. And some of them have figured out licensing to solve, you know, much like how the venues would take care of stuff before. They figured out how to solve that for the musicians that want to perform on it. And one of them has been around since 2009, actually. And like big acts would use this when they were not on tour. They would stream concerts on this site called Stage It. And Stage It has a lot of experience. You can launch shows, you can ask for donations, you can charge people, and then they take a percentage of what you make from it, and they will pay the mechanical licensing so you can do covers. You don't have to just do originals on that platform. So
cool.
That one was pretty cool and it stood out to me. But there's a whole list of all kinds of these things. There's also some new resources for if you're trying to clear stuff for sync licensing. I've forgotten the name of it now, of course, and I didn't write it down in advance, but there's new companies for trying to help people figure out how to get sync licenses. And one of them's aimed at chamber music in the kind of classical music space.
Good. Yeah. Any other topics come up?
So I think we should take a step back and maybe just talk about, if we're an independent musician, how do we get started? What do we got to do? So we're writing, maybe first we're a band, and three of us are going to be in a band, and we're going to write original songs. And so what do we need to do to get started?
Well, yeah, I mean, even let's start with one person. You're a what they call a sole proprietorship, and there's probably nothing from a formation point of view that you have to do to start being in business by yourself. You will have to account for your expenses and do your taxes for any profits that you receive, but the sole proprietorship just happens automatically. But yeah, now I want to work with a couple friends, and we want to form a band together. What are the considerations that we need to be thinking about? I think the first one is that there is a formal process if you want to incorporate. But again, you can create a partnership without any formalities, but you're better off considering maybe forming what we call a limited liability company, which you can do through the state of Minnesota's Department of State.
Minnesota has a default rule that if you are a group of people doing something with a business purpose, you're going to be considered a general partnership as a default. And so what that means is that each individual has liability for every other individual in that band. So if someone drives a van and backs into something, like, they can sue the driver, they can sue every other member of the band as well to try and recover damages for that incident, because you have unlimited personal liability.
And also in that case, any one of the partners, assuming it's just kind of this loose partnership, any one of the partners could bind the partnership, so they could make a deal with somebody, and it would apply to the whole partnership.
So that's not the best idea.
No, and then the copyright, from a copyright perspective, there's an issue too, right? Because if we're collaborating together, it's potentially we're creating what's called a joint copyright. While that sounds like a great idea, the problem with it is that, again, any member of that joint copyright ownership can exploit the intellectual property, and their only obligation is to share any profits or revenues that they receive from that. So it's very hard to control the copyright exploitation of the work too.
Yeah, in the default about co-authors, they're called authors under the statute, even if you write music or make a sculpture or anything else. It's just the Copyright Act calls you an author. And if you're considered a co-author or joint author, you are treated as a tenant in common, which is an idea that came from property law, like with land. And so you have equal rights to possess the entire work. So even if you wrote the music and the other person wrote the lyrics, you both own 50% of the music and the lyrics, the whole song. And so this is a default thing. The only way to get around that is and around the split, like it assumes, it splits per head unless you have a written agreement that says otherwise. So if we three worked on a song, even if I added 2 notes at the end, because we're by default joint authors, then I own 33% of the song, even though I did way less work. So you need to have a written agreement in order to change the defaults. And so you can change the copyright split by having a written agreement between you and your collaborators. And you can split not only the rights at the front. So there's 6 copyrights, actually different rights in the Copyright Act. And you can split 100% of those, or you can split certain of those rights. They can go all together or they can be parsed out, but you can also split revenue streams, and the split of ownership of rights can be different than the split of revenue streams. So for example, say that Kaylee and I write the song primarily, and Walt produces it. So he comes in towards the end and, you know, moves buttons and makes it sound good. And so we decide that, well, we wrote it really, and then you produced it. So we're going to own 50% each of the copyright. And then, but we're going to pay Walt 1/3 of the revenues. So even though he's not a copyright owner, he can have 1/3 of the revenues because we have a written agreement explaining that.
So, so we're going to form, we've realized that it's not a good idea to have this informal partnership. So we're going to form an LLC, a limited liability company. So we do it with the state of Minnesota, and there are default provisions in the statute that define what are the rights of the members of the LLC. But what I hope everyone took away is there are other issues that we want to put into writing too in our agreement. So we might as well draft what's called a membership or an operating agreement for the LLC, and then we can address any number of these issues in that document, and that becomes the basis for how we conduct business together as our band. Yeah,
that's like the bylaws for our band, and so that would talk about how we're splitting profits, how we're splitting expenses. You know, it's not uncommon for one person in the bands to be more business savvy or to be more experienced, and so they're kind of the one that's buying the stuff for the band to use. And so, you know, they should, how they get recouped and before profits get split, all of those kinds of things would be in that operating agreement. It also should address what happens if a member wants to leave or if a new band member wants to join, because now you've disrupted all of the equilibrium of what existed. So there needs to be policies about people coming and going. And sometimes what bands will do is everyone that's in the band, like in our scenario here, everyone that's in our band is going to be a member of our LLC. So we're going to be responsible for expenses, going to be responsible for collecting money and then splitting profits. But what you can also do is maybe not everyone wants to be an owner of the band and they just want to play and just be paid as an independent contractor. And so you can do it that way too. So, you know, maybe you've got 3 people, but one is just going to be a performer, doesn't want to deal with the business stuff. And so you just pay them, you know, to come and play, and the others deal with the LLC, the other 2 in our situation.
In that scenario with the independent contractors, what are the copyright implications of that?
You're still in trouble with the default being the co-writer's situation if you don't get something in writing. And so a lot of bands that I work with don't want to handle this in their operating agreement because they want to have flexibility to have new collaborators come in for different albums and things. So they don't want to just say like, yes, we're splitting everything 3 ways and we're splitting the copyright 3 ways and everyone gets 1/3 of everything, because then what happens on album 2 when we want to do a collaboration? So they'll deal with the LLC and however they split that out, but then they'll deal with the copyright on a per album basis. And so they'll do a new split sheet or collaborators agreement with everyone that's working on that album. And so each track even might be different. So, but if you have an independent contractor, you know, like a session musician or someone else, it's very important that you get a written agreement from them that it's called a work for hire. And that work for hire is a technical thing under the Copyright Act. A lot of times people think this is just the title of a document and like synonymous with independent contractor, and it's not. It's a very specific copyright thing. And what it means is that instead of that person having an authorship right, the person that's hiring them will own that copyright instead. And so if you have, say you hire a bass player that's not in your band, but you need a bass player for this album, and you just want to pay them to perform, you need to have a written agreement from them that says, I do not own any copyrights in the songs that I recorded with you guys, you know, especially if they're improvising their own part, because that could be considered an authorship otherwise by default. So,
yeah, the key here is in order to transfer copyrights, it has to be done in writing. And so you need a written work for hire provision that's signed by the independent contractor. And ideally it needs to be done before.
Technically,
Beforehand,
technically they need to be done before you start.
If it's not done before and you're doing it after the fact, then you actually have to have an assignment of copyright, because that musician already owns his creative output, and so now he has to transfer that to you.
Yep. And so that sounds technical and muddy, but that's how the statute looks at it. So a work for hire is used to capture the copyright before the thing exists and move it to a different author. But if the thing was already made and now you want to own it, you need what's called an assignment. So they give up their copyright to you. And that sounds gross or harsh sometimes to people. They're like, why should I take other people's copyright? But honestly, democracy is bad for commercial exploitation of songs. Like, the more people you have to ask and get to agree on what you're doing with that song, the more likely you're going to take too long and lose the opportunity.
And
so
that's why, that's why you want to avoid that joint copyright situation. You want to have the ownership centralized so that it's easy to exploit it. That's right.
Ideally, if you can have the LLC actually own the copyrights, and then you have one person that says yes or no for certain opportunities for that song. But it's totally fine and totally easy to split the revenues. Remember, because the rights, who owns the rights is separate and distinct from how you're splitting those revenues. And so you can pay the bass player royalties if you want to, but having them be a co-owner in the song with you is problematic, because now you have yet another person who's a co-author. So
I'll just add too on LLCs, when you are starting and you're gonna apply to actually formally have that LLC with Minnesota, you can actually go online and do a name search as well before you start the application, just to make sure that nobody in Minnesota already has your name that you're looking to use. And that's also on the Secretary of State's website. You could just do I think it's called business lookup, Secretary of State, and you'll find it. But as we were kind of talking to, I guess, for me, when someone wants to start a band or a business like this, really any business, the LLC, getting that formed right away is something that's really important. And I personally would put top priority, because like we talked about, you would be considered that partnership. So for me, I would kind of underline that like as one of the first things to do. And then when we were kind of talking about terms that you might want to think about in a membership agreement as well, I know a lot of people don't like to think about this stuff, but I've run into the situation where people don't when they start their LLC, is just if any of the members are married or might be getting married, like what happens if somebody gets divorced or even the death of somebody. There are laws where in the case with the divorce, the spouse of the band member could end up with a share, and then you're kind of stuck with it. And so I know some people will try to have a kind of a spousal agreement when they initially start that LLC member agreement that essentially says the spouses agree that they won't take a share. Sometimes that is not always held up in court, but another option that people will say is just, okay, if my ex-spouse is divorced or is awarded a share by the court, then they have to sell it back to the company right away. So you kind of get that person out of the LLC that you don't want, and it might cost some money. But if you don't have that kind of stuff in the agreement initially, then you could end up with issues later. And like I said, not a lot of people want to think about it right away, but it is still important to do.
Good point.
It's hard to get members out of an LLC. Like if you have a disagreement and decide you want to kick that person out, it's very hard to get members out of an LLC.
Yeah. So maybe your structure could have one individual with an LLC, and then they hire independent contractors.
I see that scenario a lot, and it's usually the oldest person in the band that is not going to be the business owner.
You know, from a negotiating standpoint, it's probably the simplest too, because it's a lot easier to be your own LLC and, you know, control your own thing than.
Yeah, we didn't talk about that, but you can be an LLC with just one person.
I'm an LLC. I've been an LLC for 25 plus years. I
think I own 4 LLCs.
Yeah.
They do different things.
Kaylee, you raised an interesting thing with the name search, which is a really good point, because you have to, in order to file your LLC, you need a name that doesn't conflict with other already registered companies. But that's an exact match, right? So it only gets kicked out if it's exactly the same name as somebody else. But talk a little about trademarks and bans, because there's a little bit difference there between the registered name for the LLC and your banned trademark.
Yeah, with trademarks, it's a little different. Like you said, really, you'll have an issue if your name is confusingly similar to somebody else's name. So even if they're not exactly the same, if they sound similar or look similar, have a similar idea, then you're not going to be able to actually register that. And so the thought with it is just that if someone else already has a band name, think of a band name.
The Eagles.
The Eagles. And they play country music, for example, and then you want to start a band named the Eagles as well, but maybe you spell Eagles really different and not in your traditional format because you're trying to be really cool, and maybe you're like a rap group or something like that. Even if you have different styles of music, and even if it's spelt differently, when people see the Eagles, if your country band, they've been performers for 15 years, they're really popular, everybody knows them, and you come in, different type of music, different way to spell it, people will see it and probably still think of that first country band when they see your name. And that's the problem. And that's why you wouldn't end up being able to register your trademark as well. It's more or less, does your trademark make people think of you when they see it, or does your trademark make people think of somebody else?
So what do I do when I come up with a great name and I do the free, I do free searches online and I don't see anything? Is there another step I should take to make sure that I really aren't going to infringe on someone else's trademark?
There's a couple places I always check, and you can get into the USPTO database. It's called TESS, and do a search there. And you want to search, like if your name was the Eagles, the word "the" is not very important there, just the word Eagles is, but you'd want to search for variations of the word or marks that include the word, but also have additional words. And you need to look and see what classes they're in, because marks might be the same name, but unrelated goods or services. And so an example of this is Delta. There's Delta Airlines and Delta Faucets, right? And they both have the name Delta, and they're allowed to coexist because no one's going to accidentally buy a faucet when they meant to buy an airline ticket.
Well, I don't know these days.
Right? but if you find someone, if Delta was a band, they're going to be in probably class 25 for merchandise, and then class 9 for recorded music, and probably class 41, which is a services class for entertainment. And so if there's already someone in those classes with a name that's close to yours, then you won't be able to get that registered on the federal register. Should mention there's such a thing as state trademarks, and most people don't file those, but it is better than nothing, just because it puts people on notice when you have a name you're using as a trademark that it is being used as a trademark. And so these are on the Minnesota website, Secretary of State website. You can search them in the same place you would go to look for business entities. It's in the same search bar. It just says trademark after it instead of business type when you pull it up. And so that can be an avenue to check too. The other thing I always look is at the domain registrars and see if the name is available, especially the .com, because that can give you an idea of if someone's already using it because the domain's gone. And then look on social media, every platform, see if people are already using it, and just a Google search.
The .com thing is interesting because we used to say that a domain name is not a trademark, and that
it's not, but it's
registered the domain name. That doesn't mean that you've done anything to protect your trademark. But there was recent case law that says you can register domain names now as trademarks. So things that almost sound generic, like car.com, can actually be a registerable trademark now.
Potentially.
So that's kind of an interesting development. But I do a lot of trademark availability searches, we call them, particularly for film and TV projects where the insurer or the distributor actually requires you to submit a formal legal opinion saying that the mark is available to be registered on the federal trademark registry. And when I do that, in addition to these other free searches and going to the trademark office search engine, I also will purchase a trademark report. I'll hire a company to do a trademark search and prepare a report, and they're usually as thick as a phone book, and they access all sorts of both public and proprietary databases to search for trademarks. Then my job is to go read through that report and do what Kaylee talked about, which is identifying ones that are the same or similar to the proposed mark. And then I look at the types of goods or services that use is connected with, and I have to make a legal judgment about whether I think that those would be potentially conflicting marks. And then I prepare a formal legal opinion, and I typically send it to the client. And then the next step is if it looks like the trademark is available to be registered, then it's going through the registration process. And Kaylee, you want to talk a little bit about what's involved in registering a trademark?
Yeah, so registering a trademark is actually, I think anyway, pretty simple. The USPTO's website, you can go on there and they have a bunch of tutorials, videos that you can watch on how to do it, and various articles that you can read. I think it's really user-friendly for someone who's just looking to do it on their own. And so you can do pretty much everything online, and it'll just kind of walk you through, ask you questions about your mark. Usually they'll ask for kind of a picture of your mark that you have that you can submit with it so they can see what it would actually look like. And then another thing to note is, and I believe the cost just went up, but I think it's about $250 to $350 depending on your
per class. So if you're doing like most bands are in 3 different classes, and so it gets pricey. But you have rights to the entire US after you make the federal register. So
the trademark registration process is not cheap. But if you're going to invest a lot of money in your marketing and branding and stuff, there is sort of a tipping point where you decide it's important to make that investment and do that. This reminds me that we hadn't talked about copyright registration, which is a much more simple.
We should talk about that. There is one question in the chat that's kind of on this trademark topic, so I do want to get to that. The question is, we have a registered mark for a logo. So just to note, you can register words as, a word mark, or a slogan is called a word mark, or you can register a design as a logo. So there's 2 different types of trademark things. I don't know what to call them. Logos or word marks. Service marks are for services, but a lot of times you'll just hear all of it called trademarks. So there's 38 different classes of goods and services. I think 9 of those are service classes and the rest are all goods. So you see TM on things, that's trademark. SM is service mark. R in the circle means it's registered on the Federal Register, whether it's a trademark or a service mark, doesn't matter. But you can only use the R in the circle when you are registered officially on the Federal Register. So if you have a logo and it's registered, what kind of authority do you have to stop others from using the logo?
Kaylee?
Yeah, so if you have something registered and it's your trademark, I believe it's still a cease and desist process. You would send them a letter and let them know that you're aware that they're using it, that you own the trademark, and that you're requesting that they stop using it. If they don't, you do have the ability to enforce your trademark essentially and bring suit against them to make them stop doing it if they won't do it on their own.
Mm-hmm.
And then,
Again, a very expensive process, so it's can be kind of daunting to consider that. But hopefully, at least they will stop using it. That's sometimes the best you can get. But
yeah, I think one of the challenges, and the follow-up question is asking about the distinction between enforcing it as a copyright work and enforcing it as a trademark. So trademark enforcement, you can really only stop people from using it as a trademark. Famous marks have more protection and more leeway for this. Like you can't put, Coca-Cola's logo in a piece of art, for example, or,
Wait, you can, but you get in trouble.
Yeah. So because they have what's considered a famous mark. And so they have more protection. They can just shut down Disney. Same thing. They can just be like, you can't use that on anything ever for any reason, not even art. So if someone's using your trademark as a trademark, you would enforce it using trademark. Tell them, stop doing that. You're not us. You're confusing consumers and you can't use our trademark. But what I've seen happen is you have a trademark. Someone thinks, oh, that's a cool design. Let's put that on a t-shirt or a mug or something. So they're not using it in a trademark way. They're just using it like a design, but then you're stuck trying to get them to stop doing that because that doesn't, that's not your product and it didn't come from you. And so there is kind of a gray area where they're using your trademark, but they're not using it as a trademark. And you can absolutely have copyright protection as well in something like a logo. This won't help with a word mark, but if it's a design thing, or a logo with fancy looking fonts or images, you could use a copyright angle to prevent things like that from happening. So then we should talk about copyright. What can you register and how?
Mm-hmm.
I noticed too, it looks like we had a question that's probably related to the one we just answered from before that also says, we have a registered service mark on our logo that was designed by a community member who's no longer alive. Is there an avenue for us to pursue full ownership? And so it sounds like when the copyright was, or when the logo was originally designed, the person who designed it kept the copyright and it was not assigned over to you at that time. So in this case, if the community member is no longer alive, it's likely their estate that you would be working with, but copyrights are assignable. And so if you did reach out to the state, they may be willing to assign it to you. And so that's all you would have to do in that case, unless Walt or Alex, any other thoughts on that?
Yeah, if it went to, if they were married and they have a spouse that's still living, it probably went to their spouse. So then you only have to find one person. But if it went to the next generation of people, you may have to find, each of their children plus their children's spouses to get permission from all of them, because now you have a co-ownership situation.
They may not even know they own the copyright.
It's very like, yeah.
So there's that question. That sort of raises an interesting difference between copyright and trademark too. If you don't use your trademark, then it loses its. The trademark, in order to keep it going, you have to use it. So if it was, if someone stopped using that name in connection with their band, then they no longer have a trademark right in that.
Yeah. The other way you can lose your trademark is something that's nicknamed genericide, which is the idea that your mark becomes ubiquitous with a certain product or service such that it's no longer a source indicator.
Right.
So it becomes generic. And so some examples, trampoline, believe it or not, that was a trademark, but now it's like, what would you call that thing?
Mm-hmm.
So
yeah.
Trampoline is no longer a trademark because it's become generic. There are certain brands that are trying to prevent their marks from becoming generic, like Kleenex and Band-Aid. They're like, it's Kleenex brand facial tissue. You'll see them reciting that, and like Band-Aid's like Band-Aid brand, whatever.
So if you have a trademark in your band, you do want to take efforts to enforce and protect your trademark rights. You don't want other groups using the name and you're not saying they can't.
Yeah, one thing you can do, even without registering, you can use the TM in, superscript to put people on notice whenever you write it out. It can be really small in your design too. If you have a logo, put TM next to it so that the public knows, like, oh, that's being used as a trademark. So they recognize that it's a trademark. But
I had a situation once with a theater, and there was a competing theater that came up and started using the same name, and they were all bent out of shape because they didn't want to go through the legal process, but they wanted to get these people to stop using the name. It was kind of an interesting.
Yeah. I was gonna say that next. Without registering, you do have trademark rights. If you're using it as a trademark, it's called common law rights, and so it's this idea that if it's being used as a trademark, it has some rights to you as the trademark owner, but you don't have as much protection as if you registered it and got it on the Federal Register. But even with common law rights, you really only have rights in the original territory where you are actually using the mark. So unlike the Federal Register where you get rights to the entire US, you only have rights, say it's the state of Minnesota and a band pops up in Michigan. And if you've never played in Michigan, you have a harder time trying to enforce your mark against them. The other thing to watch out for, and it should come up when you do your initial search, when you're deciding on your band name, make sure that no one else is already using it. But if it happens that you picked a name that someone was using before you, you can't tell them they can't use it because they were first. So they could come after you and say you can't use it. But
yeah, it works as a priority thing. That's right. Yeah. So interesting.
I will add, before we leave trademarks, when we were talking about genericide, if anybody is interested, the Velcro attorney team really pushes, and they've actually made a video online. If you look up their in-house legal counsel, they sing and dance about how you shouldn't call it Velcro, it's Velcro brand, and you should call it hook and loop fastener. So I think that's really entertaining for anybody who is just looking for a few minutes of fun from some attorneys there.
Good. Yeah. Sounds like we've exhausted that topic. So.
Yeah. So that's kind of the high level view of trademarks. Now we should talk about how do you protect your copyrights? What do you do?
Yeah.
So we talked about having written agreements at the beginning to actually document who owns what. And then assuming that, we'll just say for our example, we all signed things so that our LLC is going to own the copyright in our album. And so what do we do with it?
Yeah, so one thing that I think is really awesome about copyright law is that you have a copyright as soon as you fix your work in essentially like a fixed medium. So as soon as if you're painting, you put your paintbrush to paper and you start working, and you have a work already that is copyrightable. As well as when you write a song, as soon as you finish, you've written all the lyrics down, you have a copyright. You don't actually have to register in order to have that protection. It is still beneficial to register, and I would recommend that you would. If anybody ever infringes your copyright because you've registered, you kind of have proof that you own it, as well as registering opens up some statutory damages that are available if you do have to sue somebody for infringement that you wouldn't otherwise have access to if you did not register it.
When should I consider registering my copyright? I mean,
well, for music, you can either write it down on sheet music, or you can record it as a sound recording. So it's potentially registerable twice. You can register the written score on the form PA for performance artwork, and you can register the sound recording on form SR, and these are Copyright Office forms. You can do all of this online at ecopyright.gov, but there is a special registration to do the sound recording and also protect the underlying composition that would be written down on the score. And there's the Copyright Office has released these pamphlets called circulars that dive into specific copyright topics. And so the one to check out for that is 56A, and it talks about you can do the form SR. And if you 100% own the recording and 100% own the underlying song, then you can do that as a combination registration and just submit the recording to them. And the reason why this matters, and this is what's been in the news lately with these high profile copyright infringement cases of songs, is the rules changed back in the 70s, and music before 1978, they only could register the written music. And so what happened in those court cases that are looking at these songs is they're not allowed to play the recording. They're only looking at the score. And so they're getting some bizarre results with these jury trials about what is and what isn't infringement based on what they're allowed to show in court. And so if you do have it written down, and you're going to release sheet music in particular, it's beneficial to register the performance art form for the written music and the sound recording, so you protect the sound recording as well. But if you're just doing commercially released album, you can do the combination form SR version to do both at the same time. Well, I forgot what your question was. I'm sorry.
Oh, I think you're answering it. I'm just kind of leading the conversation.
I think it was when do you register? Ideally, you want to do it before you release the album. You can do it after, but there's a form to do up to 10 unpublished works on one group registration at the same time. And so that lets you do then 10 recordings all on one thing before you release it. If you do it after you release it, then you're stuck right now doing each one as its own registration. And that unpublished works group registration, the Copyright Office made a video walkthrough of how to do that one. That one is $85, and individually they're otherwise $65. So it's a good deal to do the group one right now. The downsides of that, there can be arguments made for why you would actually want to do each song separately when it comes to enforcement, because Kaylee was touching on something called statutory damages. If you've registered the work prior to someone infringing it, you are eligible for what's called statutory damages, which are like a fine imposed by the courts, an automatic award for that infringement. And it ranges between $750 and $30,000 per work infringed. And so you can see if you registered each of 10 songs separately and someone took your whole album, now you've got way more in statutory damages than if you did the group registration and your entire album gets counted as one work.
Right.
So there can be some advantages to spending a little more money up front and registering each song separately. But that's kind of a business decision, and what's your comfort level with risk. The alternative to statutory damages is what's referred to as actual damages. And so you don't get both. You get the choice between one or the other. And if the work is not registered prior to the infringement starting, you don't have the choice of statutory damages. You're stuck with only pursuing actual. And in most music lawsuits, that's going to be almost nothing.
And very hard to determine sometimes.
Yeah,
because
it's kind of like, what profits did you lose because they infringed, and what did they make as profits for having infringed? And so it can be almost nothing, especially if they do clever accounting and they're like, we made no profits.
How about enforcement of those copyrights? We talked about enforcing trademarks.
Yeah. So Kaylee might have experience with this too, so jump in if you want. There's a thing called the Digital Millennium Copyright Act, it's abbreviated DMCA, and that is the governing law for internet enforcement of copyright. Most websites have procedures that mirror this statute already built in. So you're probably familiar with the YouTube takedown procedures, or Facebook even, and that's mirrored after the DMCA. And so essentially what happens is the copyright owner is responsible for policing their own mark. And so if they recognize infringement happened, they can send a takedown notice to the website owner. So YouTube, for example, YouTube will take it down, and then YouTube cannot be sued for copyright infringement for having hosted infringing content. So that's the reason why these web platforms all have this built in. There is a counter notice thing. So it's because they're using an algorithm a lot of times to do the initial takedown. It's not a human. So you get a takedown you can counterclaim it. The person who, the alleged infringer can counterclaim and say, no, like that's not actually that recording and it's mine or something. And then YouTube is put in the unfortunate situation of being a copyright arbiter. And so they're trying to decide, well, is it infringing or not? And it's really unfortunate that that's who we have dealing with these issues, is a web platform that's not qualified to make those determinations and really doesn't have the manpower to do it. But if you have a registration and you have to do a takedown, you're going to be in a much better spot if they counterclaim, because a lot of times the counterclaim might be fraudulent. And so if you can show the registration, you can show YouTube like, nope, for real, it's ours. We registered it. So make sure it's taken down.
And I would say too, kind of that covers kind of the digital side of things. If you're more on the physical side of things, it's similar in that you would send a cease and desist letter to the person who is doing it, essentially asking them to stop doing it. They may or may not respond again. And if ultimately they don't, and you're unable to work something out, again, you can go to court and essentially sue them for infringement.
Which is very expensive.
Which is very expensive because copyright's a federal law, so you're in federal courts. The advice I usually hear is that unless you're going to be able to allege damages of over $150,000 or $200,000, it's not worth that. So you can scream and yell and send your cease and desist, but everybody knows that you're not going to actually file a lawsuit. So there is a change, though. Kaylee, do you want to talk about the small claims court?
I want to say one thing before we get there, but because I read a report that said that the average copyright lawsuit that actually files a court claim, they end up spending over $400,000 before the close of discovery, and that's at the point where a lot of them settle. If they go all the way through to trial, which is only like 5% of the ones filed, they spend over $700,000 on average.
I wrote an article at the ABA Journal about visual arts of photographs that were infringed on, and it was a several years long court case, and at the end of it, the copyright owner won. It was not a fair use, so the copyright owner wins, and pop the champagne corks. Only problem is the award of damages was the equivalent to a retroactive license fee, which amounted to only a couple $100.
Yeah, that's what we've been seeing in music cases too, is often like the damages award is going to be like $3,000. So it's like no one's going to file something that's going to cost them $15,000 to get $3,000 back. So
yeah, that doesn't mean you won't get cease and desist, though. I mean, they do. There are even automated processes for sending those out.
Yeah.
So
I would say in most instances, though, even if you get a cease and desist that demands money, like definitely don't ignore them, and you should try and negotiate a lower rate. Like don't just blow them off. But if you're in the position of having to send one, don't expect that you're going to get money, because it's you're going to waste time, and if you have an attorney helping you, it's going to cost you money to have written the letter, and they're not going to pay. So,
so there is a possibility to improve the situation. Kaylee, are you familiar with the small claims court that was in the one of the COVID relief packages?
I know that they did create the possibility to go to small claims court, but I don't have as much of the details.
Okay, so the CASE Act was a bill for like 10 years, and there was a lot of discussion about how a copyright small claims court would work and what mechanisms would be included. And then all of a sudden in December, you all know that this massive economic stimulus bill was passed by Congress. Buried in that 500-page bill, there's the CASE Act, and it was passed. So it's not functional yet, but there is now written into law that there will be a copyright small claims board. And essentially what it is a tribunal run by the Copyright Office. So it's like a court, but it's not itself, a court. It will have judges on it, and it's going to be limited to claims under $30,000.
Right.
So like I said, it's not operational yet, but one of the strange things about it is it's going to be an opt-out thing. And so a plaintiff can initiate this process. And if the defendant doesn't respond, they automatically lose. And this judge, have a judgment that's enforceable against them from this copyright tribunal. But if the defendant wants to, they can opt out of doing that tribunal, and then your only option is going to be to take them to court.
Right. Then you're back where we started again. Yeah.
So I don't know that it's going to be like really helpful for the independent artists trying to enforce things, but it's potentially going to provide an avenue of relief that we didn't have before.
Right.
So
interesting. How long is our session?
I think we have 10 minutes left.
Okay. Good.
So we gone through a lot of stuff.
We have.
I don't see any more new questions that might mean we made people's heads explode.
How about for the artist estate? So I'm a musician, and I've registered my copyrights. I have a trademark. I die. I think, Kaylee, you alluded to the fact that the copyrights can be inherited. So it would go, if you had a will, you'd either designate in your will who's going to receive the copyright, one or more. You can divide them any way you want, slice and dice. But if you don't specifically reference that in your will, my understanding, it goes through your residual estate. So whoever receives the residue of, they call it the residue, believe it or not,
the leftovers
of your estate, those people, that person or persons would end up owning the copyright that way. What if I don't have a will?
If you have no will, then the state essentially sets up how it's going to pass. And I'm not super familiar with how Minnesota law works in terms of who it's going to go to, but the state essentially will dictate where it goes. So,
right.
Well, I think there's different rules
with Prince, or actually dating myself, Jimi Hendrix. These were musicians that died without a will in place.
I think there's different rules too, depending on the size of the estate. And so like Prince's estate was easily over $1 million. And so it would have had a different procedure than a small estate.
I think in terms of settling the estate, but what happens if you, without a will, your next of kin will inherit your assets. So in Prince's case, it was his siblings that inherited that. In the case of Jimi Hendrix had a very fraught relationship with his parents. Guess who got his copyrights? His parents. And his dad exploited those copyrights right and left. So absent a will, there is a series of steps. It would go to the next of kin, whoever that is. If there aren't children, or if there aren't parents, then it goes to children. If it might go to a niece or nephew. It kind of works its way through a structured system. So important for everybody to at some point take the step and write a will if you want to be able to control what happens with your stuff.
Yeah, and no one wants to think about that now, but copyright, it's really important because your rights actually last 70 years after your death. And if you have co-authors, it's going to be 70 years after the death of the last remaining co-author. And so we know this industry-wide as a trend. There's a spike in value of an artist's catalog right after they died. And so you want to set things up so that you've proactively provided for, the people who are important to you, and you don't have weird things happening with the estate.
Right.
We got 5 minutes left. I think
we got a question quick.
We did. We got a question. I was just looking. I don't see a way I can type anything. So I think we should just say what firms we're with again. And if you want to maybe say your email address out loud.
Yeah, well, I can start. I'm with Mendoza Law, and my email address is Kaylee, Kaylee, at MendozaLawOffice.com.
All right, and I'm Walt Lehmann with Lehmann PLC, and my email address is Walt, W-A-L-T, at Lehmann PLC. It's Lehmann, 2 N's, PLC.com. And you can also just Google my website too.
I'm Alex Miller, AMUELLER, at hjlawfirm.com. I'm with Hellmuth and Johnson. So
Great.
let's see.
Well, we really covered a lot of ground.
Yeah, I guess like final thoughts or things to check. I do want to say, because we recorded this several months ago, MMC did a presentation about the Mechanical Licensing Collective. And some of you may have heard about that. It's brand new and it's collecting money from things like Spotify. So if you have not had a chance to watch that, that's on the MMC's website. Go and check out that webinar. That's going to talk about where to register different things so you collect different types of royalties from various places. Other things to check out, the Copyright Office website, the circulars there have good information. The Trademark Office has a lot of tutorials. They're uspto.gov. Copyright Office is copyright.gov, and their electronic application is all on ecopyright.gov or eco.gov.
I'll give a plug to the Minnesota Volunteer Lawyers for the Arts.
Yes, thanks.
A collegial organization called Springboard for the Arts, a friend of Minnesota Music Coalition, has lots of resources and materials and advice for artists of all kinds. But they're also the home of the Minnesota Volunteers for the Arts. Minnesota Lawyer Volunteers for the Arts.
Yeah.
And that group is a group of lawyers who have signed up, who have some background in a variety of issues that involve the arts. And you can contact them and get a referral, and you can actually get 30 minutes of free legal advice sometimes with one of those lawyers. So
yeah, I think, are you on the list, Kaylee? Did you join that?
Yep. Yeah, I was going to say.
So we're all three of us are on the list. You might get a one-on-one with us.
Mm-hmm.
Other resources, Kaylee, you want to add things?
No, that was it. I was just going to say, yeah, I know that Mendoza Law, we do help folks at MMC. And anytime you can just reach out to us even directly and just tell us you're with MMC. And we give you guys like a free hour of service, a nice discount. So yeah, even if you just reach out directly to us, that's fine too.
Okay.
Yep. Feel free to get in touch with us after this, by email, by phone, by social media.
Great. Well, thank you. Thank you for the opportunity, MMC, to be part of this panel discussion. I don't know how we turn ourselves off, but
I think we'll get cut off when it's time. But thanks so much for everyone for being here and listening to legal things, and we hope it was helpful for you.
Yeah. All right. Thanks, guys.